allow their president pro tem, and the members of the Senate to enter the House chamber, and the messenger will escort them to their designated seats. Members will please take their seats. I've always wanted to tell a senator that. I have some backup. Members will please take your seats. Cease conversation. We have a very special day, a very special day. Mr. Doorkeeper.
Mr. Speaker, the justices of the Supreme Court and the judges of the Court of Appeals await entrance to the House chambers.
Mr. Doorkeeper, please allow the justices of the Supreme Court and the judges of the Court of Appeals access to the chamber, and the messenger will escort them to their designated seats. Members of the House of Representatives and Senate, this joint session will come to order. Mr. Clerk, would you please read a resolution?
House Resolution 280 by Representative Abstration to the 104th, a resolution calling a joint session of the House of Representatives and the Senate for the purposes of hearing a message from the Chief Justice of the Supreme Court, inviting each other justice of the Supreme Court and each judge of the Court of Appeals to be present at the joint session.
Thank you, Mr. Clerk. Members may have their seats, be seated. And our guest. Well, good morning to all of our colleagues and our esteemed guests to have you here. We're very proud of you and the work that you do, and we're proud to have you in the House chamber today. A couple of folks I'd like to introduce that really need no introduction, but I'm going to do it anyway. A gentleman who's becoming a fast friend. Didn't know him all that well, but he's becoming a fast friend. I have great respect for the Lieutenant Governor of the state of Georgia, Lieutenant Governor Burt Jones. Let's welcome Lieutenant Governor Jones. Thank you, sir. He's doing a great job of leading the Senate, and we appreciate what you're doing there. Another dear friend, and I can say that about the Senate, a lot of dear friends in the Senate, but as a President Pro Tem of the Senate, from down in the Macon area, I believe that is. President Pro Tem of the Senate, John Kennedy. Let's recognize Senator John Kennedy.
My law school classmate.
With great honor, a great privilege, I want to recognize the pro tem of the House of Representatives. She had to step out, but the pro tem of the House is Representative Jan Jones. And we're so proud of her and the work she does on behalf of the people of Georgia. And we understand she had to step out. She was called out unexpectedly. So we'll see her in a short term, and I will report to her on the state of the judiciary when it's presented. I guarantee I'll let her know what was said. She'll be looking forward to it, no doubt, Mr. Chief Justice. Our special guest of the day, the judges of the Court of Appeals. If you'd all stand, the judges of the Court of Appeals. Thank you for your service. Now, the Supreme Court Justices of the state of Georgia, if you'll please stand so we can show you our gratitude for your service and your work. A distinguished group. Thank you for your service. Now, they said I could introduce anyone I wanted to, and it'd take me a little while to introduce all the people I'd like to introduce in this body. But I'm going to take just a moment to introduce a special guest. The lady that's put up with me for 46 years, my dear wife, Dale Burns. If y'all make Dale feel welcome. The great wisdom of Chief Justice said it probably feels like a lot longer than that to you. I'm sure it does. Now, colleagues, for purposes of an introduction, let me introduce our featured guest of the day. our honored guest who will deliver the State of the Judiciary address. No stranger to this chamber, he's a former member, having been first elected in the year of 2000. He also served previously in elected office as a judge on the Court of Appeals of Georgia and as a Superior Court judge for the Waycross Judicial Circuit. Like me, he too is a proud alumnus of Georgia Southern College. He went on to receive his Juris Doctors from the Mercer University School of Law. He served as a member of the Georgia Special Counsel on Criminal Justice Reform in 2011 and did great work there. And as co-chairman of the Georgia Criminal Justice Reform Council from 2012 to 2018, benefited this entire state on his work. He currently serves as a member of our Georgia Behavioral Health Reform and Innovation Commission, and we're indebted to him for his service in all of these areas. It's here that I'll depart from his standard biography just for a second to tell you this. He's a friend and a leader who cares deeply about the future of this state and its citizens. While he has devoted his professional career to the legal system, his heart is devoted to helping those in need, clearly evidenced about what I just told you. I consider it a great honor and a high privilege to welcome him and his colleagues of the judiciary to our House chamber today. Please join with me in welcoming the Chief Justice of the state of Georgia, Michael P. Boggs.
Thank you. Good morning, and thank you for that warm welcome. Lieutenant Governor Jones, Speaker Burns, President Pro Tem Kennedy, Speaker Pro Tem Jan Jones, members of the General Assembly, constitutional officers, Presiding Justice Pinson, and my colleagues on the Supreme Court of Georgia, Chief Judge Rickman, Vice Chief Mercier, and my friends on the Georgia Court of Appeals, and other judges who are here with us today, and my fellow Georgians. I'm honored to return to this esteemed chamber, the People's House, where I began my career in elective public service, to now present to you all as Chief Justice of the Supreme Court of Georgia, my report on the state of Georgia's judiciary. I'd like to start with a point of personal privilege to express my most sincere gratitude to many of you here today for your steadfast friendship and support over these many years of my service. I also want to thank you all in this chamber for your ongoing cooperation and support for our judiciary that has enabled all of us in the state judicial system to fulfill our constitutional obligations as the third branch of government. As I said earlier this year in hearings before the joint budget committees in January, this body has regularly shown that you understand and you appreciate the work of our state courts, and that you recognize the significant impact our work has on society and our democracy. It is my hope that this collaborative working spirit will continue to improve, strengthen, and protect the administration of justice in Georgia, and in doing so will uphold the rule of law, a goal I know we all share. Over the past 3 years of unprecedented challenges, the state's judiciary has consistently demonstrated its commitment to faithfully serving the citizens of Georgia. We remain strong and resolutely focused on the rule of law in administering justice swiftly, impartially, and independently, foundational tenets of our democracy and our system of justice. As a result, I'm pleased this morning to report to you that the state of Georgia's judiciary is strong. This strength is found, however, in the midst of challenges. This past year has been a period of hard work and significant recovery. Courts at every level in Georgia, throughout this state, are emerging from the fog of the COVID-19 pandemic, only to be confronted with new challenges presented by truly crushing caseloads. And despite the best efforts and hard work of our courts to stay as functional as possible within the bounds of health and law, many courts across this state have accrued a backlog of cases, both civil and criminal. These all resulted from significant delays in proceedings through the last several years. As my predecessors, former Chief Justices Harold Melton and David Namias, reported to this body before, the backlog could indeed take years to resolve. As they mentioned, unlike the Braves baseball games that were scratched from the calendar in 2020, never to be played again, the legal needs of Georgia's citizens continued during the pandemic and in often cases worsened. Crimes, business disputes, custody battles, resolving the unsettled estates of departed loved ones, those things did not stop simply because of a virus. They demand resolution then and now. But make no mistake, the numbers in certain parts of Georgia are truly astounding, and the resolution of these caseloads will not be easy. Let me offer up just one example. In Fulton County, where we currently sit, there are more than 4,000 pending indicted felony cases. And it's critical to note that the number of pending felony criminal cases in Fulton County that were indicted during COVID is substantially lower than the number of people arrested for felonies during that same period of time. As a result, in Fulton County, in addition to the indicted felony caseload, there are almost 14,000 unindicted felony cases currently pending. Now, Fulton County is not alone. These high case volumes are present in some other jurisdictions throughout the state as well. But it's critical for you to remember that criminal cases, unlike their civil counterpart, present significant implications on the constitutional rights of the accused. They pose serious speedy trial issues, and importantly, they affect the families of victims who are awaiting justice and closure. Fortunately, Governor Kemp has been responsive to the plea of our courts across Georgia for help. And during his first term, you're aware that he committed $96 million in federal American Rescue Plan Act funds to state courts and prosecutors, another $14 million to public defenders to address and focus on the remediation of serious violent felony cases. That funding has been used for temporary space. Our courts have used it to rent temporary courtroom space to hold jury selections or to hold jury trials. That money's been used to hire temporary personnel, including assistant prosecutors, and to pay for senior judges. And importantly, those funds have been used to upgrade and modernize courtroom IT equipment. That's especially important for our courts that are continuing to use remote proceedings. And I'm pleased to report those funds are helping. After seeing a 36.3% increase in serious violent felony cases between 2019 and 2021, the circuits that received ARPA grants have reported to us a nearly 12% decrease in those pending cases between the end of 21 and August of 22. In fact, they've seen a similar decrease among all felony cases beyond just serious violent felonies and all cases in general. In addition to those pending felony cases, the number of jury trials is also recovering across this state. After seeing a 75% drop in felony jury trials between 2019 and 20, our courts saw an increase in these trials of more than 182% by the end of 2021, and a nearly 14% in jury trials increased just during the first 8 months of 2022. But to be sure, there is still a long way to go. But our trial judges, and I want to really lift them up, our trial judges are demonstrating incredible leadership in tackling problems throughout our 50 judicial circuits. And to our trial judges, I say this: thank you. Thank you for all that you are doing and you continue to do despite challenges not seen for generations, and challenges, frankly, that we were not prepared to address. We know that you are on the front lines in the fight for the rule of law, and you should know we all depend on you. Your efforts thus far have reflected well, I think, on the judiciary. They make us all very proud, so thank you. But our work continues. The ARPA committee that I chair is continuing its hard work in implementing circuit applications for grants for calendar year 23. And based on what we've seen, you should know that the needs throughout your jurisdictions are great. We have awarded for calendar year 23, $39 million in funding to 37 judicial circuits for their efforts to remediate their case backlogs. On behalf of judges throughout Georgia, to this body, I say thank you, and we are very grateful for this funding, both to you and to Governor Kemp. Unfortunately, though, as is often the case, we've learned that money alone will not fix the problem. As you all know, workforce challenges have permeated nearly every sector of Georgia's economy, from private industry to healthcare. And you should know our system of justice, particularly our criminal justice system, is not immune to those challenges. Governor Kemp and you have made workforce one of your primary areas of focus for Georgia, and I want you to know that the courts share this focus, particularly given how workforce challenges in the judicial system continue to impede our efforts to address case backlogs. As you know, for a court system to operate effectively and justly, we need every component at full capacity. That means we need judges and prosecutors, we need public defenders and court reporters, we need clerks and interpreters and courtroom security. Without any one of those critical components, the judicial system simply doesn't work. And to be clear, our judicial system is having enormous challenges throughout the state in finding the workers it needs to fill these critical positions that justice demands. For example, the Prosecuting Attorney's Council, which supports, as you know, the DA's offices in each of our 50 judicial circuits, reports that it is experiencing its highest number of job vacancies and has the highest level of turnover in recent history. In December, just 2 months ago, PAC had 43 unfilled positions statewide. Compare that to just 11 unfilled positions in July of 20. You all know Pete Skandalakis, the executive director of PAC, and he sums it up like this, and I quote, "Our criminal justice system is labor intensive. If we have any vacancies in any of these positions, we have a standstill in cases. And before you know it, 20 cases becomes 40, and 40 cases becomes 80. We need experienced people," end quote. Pete's right. To make matters worse, the problem is especially acute in areas outside of metro area and in rural parts of this state. Let me give you an example. In Daugherty County, Albany, there are only 4 full-time prosecutors. There have been at least twice as many in the past. The circuit received ARPA grant funding in 2022 to move through its backlog of 10,000 felony pending cases. 2,500 of those 10,000 felonies involved serious violent felonies like murder, rape, armed robbery, and certain sex offenses. Really the kinds of cases where it's clearly in the public's best interest to have your most experienced prosecutors working. However, and despite that significant funding, the DA was unable to find enough lawyers interested in filling those open prosecutor positions. Meanwhile, and not surprisingly, the number of pending criminal cases grows larger, and so does the wait for defendants charged but not convicted of crimes who are sitting in local jails awaiting throughout this state indictment or trial. And of course, as you know, in our system, punishment is supposed to follow conviction, not precede it. And this pretrial delay causes other problems too. While the cost of building up our legal workforce requires a significant financial investment, and to be sure it does, it may ultimately cost less than allowing defendants to sit in jail. In Daugherty County, Chief Judge Willie Lockett, my very good friend, estimates that there are more than 200 pretrial detainees that have been in jail in Albany for 2 or more years, pretrial. At a cost of roughly $18,000 per individual, it has cost the county nearly $3.7 million to house those detainees. And of course, as I've mentioned, workforce challenges aren't exclusive just to prosecutors. Defendants accused of crime who cannot afford their own attorneys also have a right to legal representation. But public defenders' offices are also having a very difficult time recruiting and retaining lawyers. Several months ago, David Lipscomb, who chairs the Gwinnett County's Indigent Defense Governing Committee, told local reporters that before the pandemic, Gwinnett County had about 130 lawyers for defendants who couldn't afford one. During the pandemic, that 130 capacity dropped to about 80. In response, Gwinnett County, unlike a lot of other counties, but Gwinnett County added $1 million to its indigent defense budget to help recruit more lawyers. But not every county throughout the state has access to those kinds of funds. To help recruit needed public defenders, you all have been a help. That you recently passed legislation bringing parity to the starting salaries of public defenders and prosecutors, and this helps. And that parity is a tool, I think, that our state can use to recruit needed public defenders. But significant challenges still persist. In the midst of these challenges, though, and I really think it's important to recognize here the hard and often thankless work of our prosecutors and public defenders that we do have that are in the trenches in your respective communities. Our system truly depends on you doing your job and doing it well. And you've done just that, and we appreciate you beyond compare. Of course, it's not just in the criminal arena where workforce challenges are manifest. As you know, there is no right to counsel for litigants in civil cases, like divorces and child custodies and eviction proceedings, where, if you've ever been acquainted with any of those proceedings, you know the consequences are often enormous. 67 of 159 counties in Georgia have 10 or few licensed practicing lawyers. Even worse, 7 counties in Georgia, all rural, have no licensed attorneys at all. I think you would all agree with me that access to justice is a bedrock of our nation's judicial system. Yet the basic right of access is denied to many during their most dire life challenges. Now, some of you might think that fewer lawyers is a good thing. I won't ask for a vote, Mr. Speaker. Indeed, though, I also recognize that even in this body, the General Assembly has far fewer lawyers now than when I served over 2 decades ago. But as you all well know, the wheels of justice depend on lawyers. And truthfully, you may not think much of lawyers until you need one, but I'd suggest to you that there are many people in this state that need lawyers. To me, Georgia should be a national thought leader in promoting access to justice for its citizens, all 11,000 of them. And I expect you're going to hear more from our court and our Access to Justice Committee on these issues in the near future. To be sure, though, I'm very proud of how our judiciary and our judges are leading and ensuring the state of Georgia's judiciary remains strong and resilient. All across Georgia, I hope you'd be proud to know that our court's judges and legal partners are looking for innovative solutions to complex and unique problems. Along the way, they're improving the administration of justice for our citizens. Let me offer just a few examples of judiciary-led programs in our state. In juvenile court in Tifton, Judge Renderhurd's courtroom was an early adopter of remote conference technology. He employed state-of-the-art devices to keep cases and ultimately the lives of children from stalling. As the pandemic in Tifton has receded, Judge Hurd has kept this high-tech setup, like so many other judges have across the state, so that he can continue presiding over hearings and case reviews in a more efficient way. Now, the consequence is that, for instance, a psychologist living in Columbus or an ER doctor in Atlanta who's called on to testify in one of those cases doesn't have to drive the hours it takes from here to Tift County. Or a lawyer who is also a working mom doesn't have to ask for a continuance of her case when she's at home with her own sick child. Our children, who, as you know, are at the hearts of all of these cases and may well be placed in most of them in homes hours away from that 4-county circuit in Tifton, can, through this technology, still participate in their hearings. And they can be aware of decisions that are affecting their futures, all without missing full days of school. These are real scenarios that Judge Hurd has seen and resolved with his court's adoption of technology. Another innovation is occurring in Chatham County, where juvenile court judge Roxanne Formey has founded the state's first ever treatment court for minor victims of human trafficking. Appropriately called Hope Court, which stands for Healing Opportunities Through Positive Empowerment, this unique court focuses on addressing the specific needs of youth and families involved in sex and labor trafficking. The program aims to strengthen them and their communities by providing them with the support, resources, and tools they need in order to recover and lead healthy and productive lives. In addition, you should all be proud to hear that Georgia is one of the states taking a lead in expanding services to veterans, a population that has been historically underserved in this nation through our criminal justice systems. Fortunately, Georgia judges like Cobb Judicial Circuit Judge Rob Leonard are leading the charge. I also have the pleasure of serving on the Council on Criminal Justice's Veterans Justice Commission. That is a commission that is chaired by former United States Defense Secretary and U.S. Senator Chuck Hagel. It includes former Defense Secretary and White House Chief of Staff Leon Panetta. We've been working over the last year to identify really the unique needs of veterans who find themselves involved in our criminal justice system. And we've been searching for solutions that can restore their lives and lead them on a path of being healthy, productive citizens. Through our studies, we found that even though nationwide public safety officials in some places and prosecutors and courts have indeed modified their structure and objectives when addressing military veterans, only a fraction of state courts have actually established really specific justice-involved and veterans-focused interventions. You'd You'd be proud to know that Georgia, though, is leading in meeting this challenge. Through veterans courts in Georgia, eligible nonviolent defendants are diverted away from our prisons and into highly supervised, data-driven treatment programs. These programs are aimed at addressing their underlying issues. They create support and a network for success and stability. And as a result, and not surprisingly, you would not be surprised to find that the recidivism rates for these high-risk but nonviolent veterans are much lower. According to data from the Council of Accountability Court Judges in Georgia, veterans courts have among the lowest recidivism rates, with just 18% of graduates being rearrested for a felony offense within 3 years. By contrast, the recidivism rate for a non-veteran but similar individual who instead went to prison, that recidivism rate hovers between 60 and 81%. And if that's not enough to get your attention, these veterans courts also save taxpayer dollars. Veterans courts yield a savings of more than $13,000 per participant to the state, while costing less than $6,000. Last year alone, our veterans courts in Georgia served 337 military veterans throughout the state. Those courts produce real savings both budgetarily and in lives saved. On behalf of our many dedicated accountability court judges across Georgia, thank you for your continued commitment, and thank you all for continuing to support accountability court judges in this state. Beyond these examples of judges improving access to justice, our state judges are also fully engaged in improving the administration of justice for many of our citizens in our state that have serious mental illness. A few points to highlight the issue. In the United States, 1 out of 33 adults is behind bars. That's 1 in 33 adults is incarcerated in the U.S. You might be surprised to learn that in Georgia, the number is 1 in 13. Since 1980, in Georgia, the number of people going to jail has tripled, and the length of sentence has increased by 166%. I believe that much of this is attributable to deficiencies in our mental health service delivery systems. Nationwide, nearly a fifth of jail admissions involves a person with serious mental illness, a fifth. We also know that people in the United States with mental illness are 10 times more likely to be incarcerated than hospitalized. They're 19 times more likely to find a bed in the criminal justice system than at a state civil hospital. And while those with mental illness in the United States and in Georgia are traditionally arrested for fairly minor offenses, often like criminal trespass or loitering, empirical data demonstrates that once incarcerated, this population tends to stay in jail 4 to 8 times longer than their counterparts at 7 times the cost. In our own Department of Corrections, the mental health population has grown 100% in the last 2 decades, such that now in Georgia and at the Department of Corrections, a full 25% of the entire incarcerated population is identified as having a mental health issue. And on top of the really enormous moral and fiscal impacts that I've just highlighted, public safety is also adversely affected, because we know in the United States that just a day or 2 in jail for this population increases their recidivism rates by 40%. Thankfully, Governor Kemp and all of you have recognized the importance of addressing this very significant problem in creating and supporting the work of the Governor's Behavioral Health Reform and Innovation Commission, a commission on which I serve. Your efforts have ensured that Georgia continues to lead the country in thoughtfully and responsibly addressing this issue. Sincerely, I truly thank all of you for your overwhelming support last year and this year of the recommendations of the commission, and I trust that you recognize that your efforts reflect well on the priorities of our state. I also want to take a moment to acknowledge on this particular issue the critical leadership of late Speaker David Ralston, and thank Speaker John Burns for continuing Speaker Ralston's legacy in this regard. We wouldn't be here without Speaker Ralston, and I'm just so thoroughly thankful for my friendship with him and for his leadership. I also want to especially recognize and thank Judge Amanda Mercier, Judge Brenda Weaver, Judge Kathy Goslin, Judge Brian Amaro, and Judge Sarah Harris for their commitment to taking time and the effort necessary to assist the Behavioral Health Commission and the subcommittee on which I chair to improve access to justice for this population and to improve outcomes. Another way our court leaders are working to ensure that our citizens have meaningful access to justice is through our Judicial Council's Committee on Court Interpreters. They recently completed reviewing and updating the rules that govern court interpreting in our state. Of course, as you know, as Georgia's population is becoming increasingly diverse, it is imperative that our state courts continue to be accessible to everyone. I'd particularly like to recognize my colleague, Justice Carla Wong McMillan, and Suwannee Municipal Court Judge Norman Quadra for their efforts to lead this work. Thank you. In addition to these tremendous examples, I think, of judiciary-led leaderships and initiatives, let me lift up an initiative in which one of our legal partners is also helping some of Georgia's most vulnerable children. Through a medical legal partnership, our state's legal practitioners, lawyers, are assisting children with significant health risks and chronic illnesses. In 2004, Atlanta Legal Aid pioneered a health law partnership known as HELP, where they stationed lawyers in each of the hospitals run by Children's Healthcare of Atlanta, and they established a law clinic at Georgia State University with the purpose to assist low-income families with legal problems that affect the health and well-being of these medically fragile children. In fact, through the work of these medical legal partnerships, 5 children in Georgia have received new hearts when they otherwise would not have been eligible. Help lawyers work. Thank you. These help lawyers work with doctors and social workers and nurses while these children are hospitalized in order to provide services for these children who are already, of course, receiving care. They intervene to address underlying conditions that harm the children's health, such as poor housing conditions, which can magnify chronic illnesses like asthma or sickle cell disease. They seek to assist to secure necessary special education services for developmentally disabled children in Georgia. They facilitated custody for infants with terminal cardiac conditions that allowed them to be placed in supportive home environments and in turn be eligible for these life-saving heart transplants. And in fact, during 2020 alone, these lawyers worked on more than 640 cases, serving 387 unique clients. Their work resulted in savings of $1.2 million in housing, education, family law, insurance, and public benefits. I hope you will continue to find ways to support this program, this initiative, and these lawyers in this critical work supporting Georgia's most vulnerable children. Before I wrap up, and that will be soon, I promise, try to end on a note that I hope you can all appreciate. If you've ever been in our courtroom or you've ever watched the live stream of our oral arguments, you see engraved in the granite above our courtroom, above our bench, a Latin phrase that is essentially translated to this: "Let justice be done, though the heavens may fall." We're reminded of that phrase every time we enter our courtroom. To me, and I hope to you, that phrase uniquely encompasses the duty of judges, singularly encompasses the duty of judges. Judges are called upon to interpret the law and the Constitution. It's not our duty, nor should it be, to change the law or the Constitution. We don't render decisions based on our own desires or our own bent of will, but rather we follow what the statutes and the Constitution require. And in doing so, we respect and appreciate the separation of powers and the awesome responsibility you all have as legislators to craft and shape the laws of our state. This is the embodiment of the separation of powers, and this is the rule of law. However, underpinning the rule of law is the safety of our judges. Our judicial system depends on judges deciding cases without fear. This includes fear for their personal safety or the safety of their families. The Chief Justice of the United States has made court security the centerpiece of his recent annual report, where he stated, and I quote, "The law requires every judge to swear an oath to perform his or her work without fear or favor, but we must support judges by ensuring their safety. A judicial system cannot and should not live in fear," end quote. I have the pleasure of serving as chair of the Judicial Council of Georgia, and in doing so, I want to give a voice to judges all across our state who have an interest in this issue. And so you can expect that judicial security will be an area of focus as this year progresses. And in fact, just last month, I'm proud of our court for creating a new Judicial Council Standing Committee on Judicial Security that will be chaired by my good friend and colleague, Justice Sean Ellen LaGrua. That committee will be focusing on security challenges to Georgia's judges, particularly those challenges outside the courthouse. I'm aware of ongoing efforts by the General Assembly to address this issue this year. I appreciate that effort, and I hope you know that you can expect some further recommendations from our committee for your possible consideration next year. Your interest in this issue is really underpinning the entire rule of law in our state, and I'm so appreciative for what you are doing to address it. As I close, let me just simply say this. I'm very optimistic about the year ahead for the state judiciary. Our courts are making significant progress in moving cases, in improving access to justice, in improving the administration of justice, and in steadfastly upholding the rule of law. Thank you again, Mr. Speaker, for inviting me to speak on behalf of the Supreme Court, as well as on behalf of Georgia's judicial branch this morning. I wish you all a productive balance of the session. May God bless you and your families, and may God bless the great state of Georgia. Thank you. Thank you.
Wow. Our Chief Justice. Thank you, Justice Boggs, for informing all of us to ensure that we know the facts about our justice system in Georgia. Two more comments. Georgia is the best place to live, work, and play. I like to add play in this nation, but one of those reasons is because of our justice system. It's the dedicated judges that I see in front of me, justices, and the judges around this state that make it just that. A great place to live where you feel comfortable that justice will be served. And I'm so proud to have invited y'all here today and have our presentation on the state of the judiciary. And one last comment. You have the heart and intellect of a judge. There's no doubt about that. But you have the heart of a compassionate man, individual that wants and is serving all of the people of Georgia. And we love you and appreciate you. If I could say that about a justice. At this time, I'll ask the doorkeeper to escort the Supreme Court justices and the judges of the Court of Appeals from the chamber. Mr. Doorkeeper. The majority leader of this House, Leader F. Stration, is recognized for a motion.
Thank you, Mr. Speaker. I move that this joint session now be dissolved.
The majority leader of this House has moved that this joint session be dissolved. All those in favor of the motion will say aye. All those opposed say no. No. The ayes clearly have it, there's no doubt, and this joint session is thereby dissolved.